We continue our discussion of the right to privacy now with a discussion of the case Roe v. Wade. This is a case that has, of course, caused a considerable amount of contention and upheaval in American politics. However, I don't think that people have really considered much the difficulties the court went through in making a determination and also of what that discussion consisted. I don't know that that would change anyone's opinion about on the topic, but it most certainly would cast our public discussion about the case and about abortion in a very different light. So we concluded the last lecture by discussing a case called Griswold versus Connecticut, in which the court determined that there was a fundamental right to marital privacy and a fundamental right to obtain for married people to obtain contraceptives as part of a general right to privacy. The court determined that the right was fundamental because it existed as part of emanations of other rights that are specifically listed in the Constitution and the Bill of Rights. Other justices, however, decided that the court had gotten it wrong. For example, Justice Goldberg agreed with the outcome that the right was fundamental, but he lodged the right to privacy in the Ninth Amendment. And then Justice Harlan goes on to take it a step further than either Douglas or Goldberg and say that they don't even have to look very far past the Due Process Clause of the 14th Amendment to find a justification for a right to privacy. He says, while the relevant inquiry may be aided by resort to one or more of the provisions of the Bill of Rights, it does not depend on them or any of their radiations. All you have to look to is the Due Process Clause to find out whether the right is fundamental. Other justices determined that the right was not fundamental at all. One justice, Justice Stewart, said he thought the law was uncommonly silly, but it wasn't unconstitutional. And other justices, for example, Justice Black, raised the specter of Lochner versus New York when he said that I thought we had abandoned substantive due process for all time, but here it is coming back again to haunt us. That leads us into this next case, and let's begin by discussing standards for deciding privacy cases. So I noted in the last lecture that other cases following Griswold involving privacy were decided using rational basis, and we said that rational basis is the lowest bar for the government to get over. If something is not considered a fundamental right, then the state only needs to show that it has some legitimate interest and that the policy regulating conduct is rationally related to that legitimate interest, thus the name rational basis. This is a very easy bar for governments to get over. One other option, of course, is strict scrutiny, also called preferred freedoms. If something is a fundamental right, the state must have a compelling interest to regulate it. We said that some compelling interests include war, and also diversity in higher education is considered a compelling interest. Here we have the docket sheet for the case Jane Roe et al. Versus Henry Wade. And you can see that one justice, Justice Blackmun, has kept a very close record, actually, and this is actually the court's docket sheet, the official designation of who voted where. Now look down at the bottom where it says Rehnquist J. He's at the top there, and Powell, Blackmun, Marshall, White, Stewart, Brennan, Douglas, and Berger, and Berger being the Chief Justice. And then if you look across from those, you can see a column that says cert. We discussed that in the first section. That has to do with whether the court is going to grant or deny certiorari. Obviously, they granted cert in this case. The jurisdictional statement, there's a number of options, 4 options there. And that just determined whether the court found that it could exercise jurisdiction, whether an individual such as Jane Roe had standing to sue, the child had already been born, so did she have standing? The court determined that she did, that she couldn't lose her standing simply because it took longer than 9 months to get a case up to the Supreme Court. And of course, it only takes 9 months for a child to go through gestation. So they decide that they can exercise jurisdiction. And then we get to the merits column. And you'll see 7 check marks in the affirm column and only 2, Justice Rehnquist and Justice White, who are voting to reverse. Now, I know it seems kind of strange. It's Roe versus Wade, and it looks like the court is affirming Texas, right? Because Texas is the respondent, and they would want the case to be confirmed. But actually, what they're doing there, just because of the record below and the decisions of the court below, they're actually affirming portions of the court decision of the court below and voting to reverse. So there's the docket sheet that they kept of the 9 justices deciding. So okay, so the question in Roe versus Wade was, is an abortion a fundamental right under the privacy standards set out in Griswold versus Connecticut? And the court votes yes, 7-2, majority opinion by Blackmun, but that's misleading, because they didn't apply the privacy standard in Griswold completely. The court makes a distinction between first trimester interests, second and third trimester interests, and they call that the trimester framework. So the Griswold standard of privacy actually applies only during the first trimester, in which the court says the mother has the highest interest in her privacy and exercising the right to abortion, and the state's interest in preserving life is lowest. Then the state's and the mother's interest balance out in the second trimester, and in the third trimester, the state must only get over the low bar, rational basis, to justify regulating the right to abortion, because the state's interest in life is paramount. Now, if the state is going to regulate during the first trimester, they would have to demonstrate, the state would have to demonstrate that it had a compelling interest to do so. The court says the right to privacy is broad enough to encompass a woman's decision whether to terminate a pregnancy. The detriments of not giving a woman this right reach to financial, psychological, and physical harms. And you should look very closely at the court's, in the text, the court's discussion of the right, and then also look at table 16-2 that outlines the Roe v. Wade trimester scheme. It's very important to understand that the court didn't apply a straightforward fundamental right analysis to abortion. In fact, and this is something that most people don't understand, the court has never declared the right to abortion a fundamental right in every instance. And in fact, the court has gone on to say in later cases that it will evaluate the right not using a fundamental basis standard, but something called the undue burden standard, which is a very different. It's sort of a medium level standard that comes in cases following Roe versus Wade. Here's a memorandum from Justice Harry Blackmun, who wrote the decision, and you'll notice he says at the bottom, I apologize for the rambling character of the memorandum and for its undue length. It has been an interesting assignment. As I stated in conference, the decision, however made, will probably result in the courts being severely criticized. And he certainly was right about that. Okay, so post-Roe, we're talking about a set of cases in which the court upholds government regulations of various forms. In the Harris versus McCrae case, the court said Medicaid does not have to pay for abortions, and in fact, federal government money since 1980 has never been used to pay for abortions. In Akron, the court struck down certain provisions that limited access to abortion, and O'Connor dissents in this case, but the reason she does so is because she articulates a new standard. She says the Roe framework has become, trimester framework has become unworkable, and the court needs to substitute something else. Um, in Thornburg versus American College of Obstetrician and Gynecologist, the court ruled in favor of the right to abortion and upheld certain state regulations, but Berger switches to the overturned Roe camp. And in Webster, the court says that public facilities are not required to perform abortions, and states can even go so far as to proscribe abortions to stop them completely after viability. But the court says in Webster that the states can determine for themselves what restrictions that they will place upon the right. And so the court sort of, instead of overturning Roe, it kicks the football back to the states and says, now the ball is on your side of the field and you can decide what kind of restrictions you want to place on the right to abortion. At that point, almost literally, all hell breaks loose in the state legislatures as the pro-life and the pro-choice sides mobilize. There's considerable public conflict. There's shooting at abortion clinics. There's picketing outside of abortion clinics. An abortion doctor was assassinated, a doctor working at that facility. There is just a tremendous amount of public upheaval during this time, and the court take notice of it. And in a case following Webster, a case called Casey, the court actually overturns the logic of Roe, and it substitutes what's called the undue burden approach to abortion analysis. So it upholds the idea that abortion is a right, but then it says the trimester approach is not working at all. In fact, medical science has pushed back the point at which a baby can live outside the womb of the mother, continues to push it back in time. Medical technology is improving the chances of a child surviving outside the womb. And so we can't, it's like hitting a moving target to say where a woman's right to abortion ends and where the state's right to life begins. So the court substitutes this test, the undue burden test. It says that anything that places an undue burden on the fundamental right to obtain an abortion is subject to strict scrutiny. But any other forms of regulation are just simply evaluated using a rational basis. So the court adopts this kind of, in this case, Planned Parenthood versus Casey, Planned Parenthood versus Casey. It's a plurality of individuals, 4 justices sign on to Justice O'Connor's decision. There is, or opinion, and there is no majority opinion that emerges from this case, just a plurality. This sort of shows you the ways in which justices kind of keep track of opinions and who falls where and what the diagram is that leads to like this 5-4 decision. This was Justice Kennedy describing his position with respect to the Planned Parenthood versus Casey substitution of the undue burden test. Okay, when we come back, we will talk about Planned Parenthood versus Casey and the court's substitution of the undue burden test and what that looks like. Thanks for listening.